And hello, everyone, and welcome to the Copyright 2.0 show, episode number 379. My name is Jonathan Bailey. I am from the website Plagiarism Today, which can be found at plagiarismtoday.com. And joining me, as usual, now that we're on the irregular schedule that we're on, is attorney Evan Cherez, who I would like to remind everyone that while he is an attorney, he is not here to dispense legal advice. You want legal advice from him? Pay the man. And you probably should. He's a really, really nice guy.
I always appreciate your endorsement, John.
Evan, how are you doing, man?
I'm doing well. The weather's gorgeous here in DC. It seems like winter is finally ended, which is I'm a big fan. It has released its grip, and I'm excited to, once again, even though it's less often than it was before, I'm excited to talk some copyright.
Yes, well, and you're talking about how lovely and wonderful the weather is there, and here we're getting warnings of like this apocalyptic storm coming our way. And it's kind of bad because I leave in a car tomorrow afternoon, evening to head to South by Southwest in Austin. So,
oh, that's awesome. I've always wanted to go. What's the reason for that?
Speaking, actually, I am giving a panel on the 15th about web scraping.
Web scraping?
Yes.
Interesting.
Yeah, this is where I should be telling you exactly when the panel is, but I just realized I have the wrong information up on my screen because they moved it and I forgot about it. So hang on one second. Let me get that to you, and that way I can do the pitch properly. Yes, the panel is entitled Digital Content and the Legality of Web Scraping. It's March 15th. It's 9:30 to 10:30 a.m. It'll be at the JW Marriott Salon 5. I guess there are 4 others. I will be talking along with attorney Katie Sundstrom and Rami Essaid of Distill Networks, an anti-scraping technology company. So it's an intermediate level. I did not actually. It's weird. Usually when I speak at South by, I'm pitching the talks, so I know every little detail about the pitch religiously. It's like, we're intermediate? I didn't know that.
I've heard very good things about Salon 5. Number one salon there. So
the best salon. All right.
Number 5 numerically, but number 1 in our hearts.
There you go. That's how it should be. Yeah, there was some kind of scheduling conflict. It got moved at the last minute. That's why there was a little confusion on my part. I apologize. It's available. It's on the South by Southwest interactive track. So if you are attending South by, please swing by and see me, see Katie, see Rami. And also I should give props to our moderator, Orion Cassetto, who is doing an excellent job keeping the cats well herded for this.
Okay. Well, why don't we dive into our stories today?
Yeah, we have a lot going on this week, and not to mention a new platform for our show notes. Yay! I know that seems like a minor deal, but we were supposed to record yesterday, and we had some technical difficulties. So now we're on another system. But long story short, we're going to start off this week talking about Happy Birthday, the tentative settlement there. And also, it's kind of a settlement palooza this week, isn't it? Because Fox and Dish Network settled their dispute over ad skipping. Fox News settles a dispute over the iconic 9/11 photograph. RealMassive and CoStar hammer out a settlement. And a settlement that is like the supreme last-minute settlement. Jookin Media and Equals 3 settled their YouTube-oriented case. But because, we can't just have settlements, we have the RIAA and their case against MP3 Skull. And then sort of an academic exercise here, but the U.S. Copyright Office and its new rules on making available, its new report, I should say. And then we take a look at the Department of Justice and what they're doing with 100% licensing. And finally, we wrap it up by talking about the Batmobile, because I want to talk about the flipping Batmobile.
I thought the Batmobile was our leading story. Seems I've got our order a little out of sorts, but I will follow you as best as I can.
Okay, maybe the show notes didn't transfer in the same order. This could be interesting.
Just as we were praising our new platform.
Yes, this is us learning as we go on this new platform. Okay. This is interesting. I'm a little bit caught unawares. Okay, do you have the other stories relatively in order?
Why don't I just follow you and I'll find them in my notes.
All right, I'll take the lead on this then. I'm learning stuff today. Well, first off this week, Happy Birthday has been settled. The lawsuit over what is known as the world's most famous English language song has been settled. Well, it's a tentative settlement. I believe it's now been approved. And it basically has Warner Chappell admitting, at least in their mind, that the song is now in the public domain. It also has them paying some $14 million in royalties and paid back $14 million in royalties to people who paid to license the song previously.
Right. I believe this is our misnomer headline of the week. We usually have one.
Yep. Oh, yeah. It's not a
every show
if we don't have an egregious...
Right. We've discussed this before. Just because the individual or the corporation in this case can no longer prove their ownership does not make it, quote unquote, in the public domain. Now, for all practical purposes, it does, because there's no one, at least that we can see, that can legitimately claim to own the copyright, but it does not put it in the public domain. It becomes more of an orphan work where its copyright still exists, but we do not know who really owns it. But it is not in the public domain in the legal sense.
Yeah, and that's one of those weird things is you don't really get rulings that a work is in the public domain. That's not how it goes down. It's typically, especially with music, the ruling you get is that so-and-so doesn't have a legitimate claim to the copyright of it.
Right.
And that's what happened here. And my personal belief, and the personal belief of many, many others, is that the song is indeed public domain for a variety of reasons.
Right. I share that as well, but it's just important that
the judge did not wave a wand and put it in the public domain.
Exactly. It's important that we accurately portray its status, because this is an intermediate, at least, level podcast.
Yes. Well, I've got to say, though, I just had a thought when that statement. Evan, do you have any idea why judges have gavels and not wands? I think it'd be much more kick-ass if they could wave wands with their verdicts. I think that'd be much more intimidating sometimes.
I haven't given it much thought. You might be surprised to hear why judges don't have wands.
I do not know. This is a question for the days. But yeah, you're absolutely right, though. The judge in this case ruled previously that Warner Chappell Music, the claimant, that they were the ones claiming the rights here, did not have a legitimate claim. And the result of that is, well, there's no one else who we know of who has such a claim. It doesn't mean there couldn't be someone down the road who could stand up and go, I've got one. And we start this whole fiasco all over again. So, yeah, it's a very important ruling, and it does mean that if you wish to sing Happy Birthday in your restaurant or have it in your movie or TV show, you're probably safe. But, yeah, just let's use the language appropriately. Words
exactly. We've been following the story, so I'm glad that we can finally put it to bed, because we have talked about this quite a bit. Some of the details are that there's a $4.6 million legal fee bill that's being asked to be paid for. So that gives you an idea how long they've been litigating this issue. $4.6 million in legal bills is not nothing.
No, it's quite a lot of something, actually. I can't pay $4.6 million in legal bills.
Right. Well, Warner Chappell Music is no longer able to collect what was a $2 million per year royalty revenue stream, which is not chump change either.
Yeah, exactly. And this is not a trivial amount of money, but then again, to a publisher the size of Warner Chappell, it's probably not as big as it would be to you and me. This was supposedly one of their most lucrative songs, but they are a publisher with a very, very large catalog. I'm sure that they will survive this loss.
Right, and excuse me, I meant it was the lawyers battled against Warner Music who are seeking to have their legal.
Oh yes.
The legal fee from that firm is what's requested being paid for, because as we've discussed many times, that there's a huge discretion to the judge to give to cover the legal costs of the winning side.
Yep, and I've got to say that's kind of always one of the more interesting elements when it comes to attorney's fees, is you always hear the two sides get into I deserve this insane amount. No, you deserve this insanely low amount. And the judge kind of puts his head in his hands and goes, okay, this. I decide this. And that's the end of it.
Yeah, well, I think that brings us to our next story, the Fox.
Yes. So that
Fox
did work.
story.
Fox, yeah, you can take this one.
Sure. Fox Broadcasting and Dish Network have settled their lawsuit again. That's our theme this week, settlements, over the AutoHop service, which has been litigated over the past few years. It's the technology that includes automatic ad skipping, which was obviously the big issue here. The terms of the settlement, as usual, were not disclosed, but in the joint statement, the two parties basically saying that, hey, we've come to terms, and sorry, but Dish's AutoHop commercial skipping feature is not going to be available on Fox stations until 7 days after the program airs, which I think is a reasonable compromise.
Yeah, I think it's fairly reasonable, all things considered. And it's pretty interesting because the copyright element of this case was already decided by the judge in Dish's favor. The judge had ruled that the removal of commercials was not a copyright infringement, but what remained was a contract issue because there were allegations by Fox that in addition to the copyright issues, the AutoHop feature violated terms of agreements they had signed, including providing like an on-demand streaming service. They couldn't like turn the channels to an on-demand streaming service, for example.
Right.
And that was what they were alleging Dish was basically doing. And that issue has led to, and this is something I learned very recently because we're looking as a family at going back to cutting the cord. We cut the cord, we regained the umbilical cord. It's like the worst set of triplets ever. You know, it's like the cord's attached, the cord's not attached, worst labor ever. But anyways, we're looking at going back to going without cable, or in our case, it's actually DirecTV. And part of that is we're looking at building our own DVR. And what's interesting is a lot of software applications since this ruling have popped up to do exactly this feature on a standalone DVR that you build.
Wow.
So I thought that was very fascinating. I haven't made a decision if we're going to use it or not. I don't think we are. But it was just interesting that it exists when we're reading these guides about setting up your own DVR. It was pretty cool.
Yeah, you mentioned the copyright ruling last year. Now to briefly touch upon it, or maybe not last year. Was it 2015 or 2014? Anyways, it had come down at about the time the Aereo case had come down, and Fox had argued that that landmark ruling from the Supreme Court on Aereo really related to the Dish case, but the judge found differently because whereas Aereo streamed a subscriber-specific copy of its programming from their hard drive to their subscriber screen via an individual satellite, Dish Anywhere basically it was used by a subscriber who was already paying for it to gain access to their own authorized recorded content on the box. Yeah. So that was the big distinction. And
there was also the issue that Aereo did not have retransmission rights, and no, Dish does.
That's right.
There's just a question of does this violate those rights? So yeah, this was an interesting case, and I got to say the settlement seems, I agree with you, fair. I mean, this gives Fox a chance to exploit their content, I think, reasonably. I don't think there's much harm to them, or after 7 days that they that there's automatic ad skipping enabled. But that being said, this is kind of how these settlements work. They fight for a while. They get a few rulings. They see who has the upper hand, what way the wind blows, and then a settlement happens based upon that. That's hopefully advantageous to everyone.
Yeah, agreed. Okay, that brings us to Fox News.
Yeah, Fox News. This one is really interesting to me. Fox News. Go ahead.
I always found copyright litigation cases, because there have been numerous that surround famous 9/11 photographs, to be particularly bad for the field of copyright generally. It just leaves a bad taste in everyone's mouth when they hear about it. And while, of course, I respect the hard work of photographers, I just don't think that 9/11 puts copyright's best face forward.
I agree, and to me, I often compare this to what the the heirs to the Martin Luther King Jr. estate have done with his works. It's very similar in that regard, in that it's legal, yes, but yeah, you're right. It leaves a bad taste in everyone's mouth. And when people start talking about we need to repeal copyright or severely curtail it, these are the types of things they point to.
Exactly. So this these copyright lawsuits that we're going to be talking about for this case center around that iconic photo of 3 firefighters raising the U.S. flag at the site of the World Trade Center ruins following the September 11th.
And the photo was actually the basis for a statue that was also placed near Ground Zero, if I remember correctly.
Right, so we're talking about a photograph of significant public importance, and that's what tends to be used against pro-copyright arguments when someone brings up, hey, what about this photograph? It's of such national importance. We should be able to share it. It dishonors 9/11 when you try to stop people from sharing it. But what I like to say is that these are two media companies fighting against each other. This is not an individual. This is not a charity. Although it's of course going to be a gray area if it was a charity. Excuse me. These are two media companies fighting against each other, so I think that's important. These are two for-profit media organizations. Yeah. In this case, the North Jersey Media Group goes by NJMG.
And I keep wanting to call them the New Jersey Media Group just because, you see NJMG and you think New Jersey, but that's just me.
Right. So they had a number of copyright claims against Fox News, who were using the photograph. It initially surfaced on Fox, I believe it was through their Facebook page, if I read that correctly. Right. It was one of their personalities' Facebook pages that published the photograph.
That's correct. And it actually appeared, well, there's two separate lawsuits, but, and that was kind of the weird thing about it. They did it once, and then they doubled down and did it the exact same thing again.
Right. One of them was juxtaposed to the famous U.S. Marine raising the American flag in Iwo Jima photograph. And basically there was an argument, hey, this is fair use, but it did not. Ended up carrying the day, and the two parties settled.
Yeah. And long and short of it is the two sides have reached a settlement, as with I think pretty much all the ones we're covering today. Well, first off, it should be worth noting the two lawsuits were consolidated because that's kind of how these things work. Judges want the simplest path, and if they get two cases with the same two parties and the same two facts, largely they're going to condense them.
Right. So let me ask you your opinion. Fox had it in court papers heading into trial that it used a visually altered, significantly cropped, and low-resolution versions of the photo that were for the purposes of news reporting or commentary and fell under the fair use provision. Now, those are, I think, I think those are fairly compelling arguments. They were trying to make a transformative use case.
Yeah. And, okay, the low resolution, that pretty much plays straight into the Perfect 10 v. Google case, which was the case where Perfect 10, the pornography company, sued Google over Google image search, and Google won the day with a fair use argument saying that all we're hosting and all we're creating are thumbnails, and it's for the purpose of a search engine. It's transformative fair use.
Right. Well, I think there's a big difference between low resolution and thumbnail, though.
Yeah, I would agree with that, but they were trying to use some of the same language and verbiage that came up in that case.
Right. I think that's exactly what's happening. I think there's a very deliberate use of vocabulary in order to mimic that very well-known case.
Basically, I think they're playing fair use Scrabble a little bit here by throwing out all the right words and hoping it comes together in a cohesive argument.
I agree with that. Like visually altered. We changed it, is what they're saying. But, I mean, I pulled up the photograph. I don't think there was a significant case for that. It's available on Google Image if you want to look for it. Just look for that comparison that I mentioned earlier, the Iwo Jima and 9/11 photograph, if any listeners want to take a look at the photograph.
And my thought about it is the low resolution argument doesn't work for me because one of the things North Jersey Media Group does is they license it for use on the web. They lower the resolution from print to web, which is still perfectly marketable for North Jersey Media Group. I don't think they made significant changes by cropping or any of that stuff either. The best argument they have is that this is for news reporting, but they weren't actually reporting news. They were doing like an homage, please remember September 11th thing, which, while is not bad to do, may, or, depending upon your definition of news reporting, may not meet that qualification.
Right. I think that while they try to evoke this transformative factor, the transformative use is really about the purpose and the character of your use.
Great,
You
exactly.
spoke to that directly, which is, they were using the photograph in exactly the same way that the original owners of this photograph intended to use it. It was evoking patriotism, paying homage. That was really how this photograph was used. So there's been no added new expression or meaning to it. Comparing it to another photograph whose primary use has been homage, which is the Iwo Jima photograph, doesn't do that. It doesn't transform it. It's really more of the same. And was value added to the original by creating new information, new aesthetics, new insights or understandings? I don't think so.
I don't think so either. It makes me feel weird, but I have to agree with North Jersey Media Group for the most part. I think the fair use arguments were pretty weak at the end of the day. It was like I said, fair use Scrabble was being played. He said all the right words, but
we couldn't back it up. I agree.
Right. So yeah, and what's interesting about this, and one thing I was just thinking about was, with these cases leaving a bad taste in our mutual mouths, I think it'd be interesting if there were a charity created for the purpose of buying up the rights to works like this that are so iconic and so important to American history, and then just releasing them under a CC0 license.
Right. I'm just reading now, John, that you tweeted out to join us while we talk copyrighty stuff. So yep. I just wanted to let you know that I appreciate the angle of professionalism that you always add to our discussions.
I couldn't resist. I was thinking fast. I had to think of something pithy quick because I completely forgot to do it before I got on the podcast. But yes, copyrighty stuff is what's going on this show. Hey, it's not. At least I didn't say legal advice. But yeah.
All right, let's move on.
Real estate, huh?
Let's move on to real estate.
Yeah, this one is interesting. This one really fascinated me because Crystal here has done some work in real estate photography. So I was actually really kind of keeping a closer eye on this one in a lot of cases.
Right, and my cousin Rob works in a small commercial practice, is actually telling me about a potential client that he had who had a very similar problem. So I think this is likely an issue that really plagues real estate, because pictures are so important in real estate, and
so difficult to get.
So difficult to get great photographs of a house. And I feel like, real estate agents may not be so well versed, in copyright issues and photographers. And I feel like the general population, and maybe this is not correct to say, but most people tend to dismiss the value of a photograph as compared to what it really means to a photographer.
I would agree with that. And I will say this, I know several licensed realtors here in Louisiana, and none of them were asked about copyright on the realtor's exam. So it does not come up in the training. At least it didn't when they took it. I don't know if that's maybe changed, but yeah, it's a real interesting problem. And basically with this case, you've got a company called RealMassive. They are a startup, if you will, a disruptor in this field of real estate listings. And then you have the established player, CoStar Group Incorporated, who they're the established player because in this article in Biz Journals, they've got the NASDAQ listing beside the name. It's like, well, guess which one of these is the startup?
Is it the one with the... I looked at the photograph and I knew it was them right away because he was wearing a T-shirt with his company's name on it. There seemed to be an open space work environment, so you knew right away that was the picture of the startup.
Yeah. Well, no, I think it's the startup because he's got the T-shirt with the logo on it and the open blazer over. That's like such a Zuckerberg type.
Yeah, open blazer and a T-shirt.
Yeah, that's something you only get away with in Silicon Valley, I think. But yeah, anyways, RealMassive which is launched now in 33 markets, has worked to create this really great database, really awesome database of real estate listings to compete with CoStar. However, at some point in the operation, photographs owned by CoStar ended up in RealMassive's database, despite what RealMassive said was their best efforts to prevent that from happening. That prompted CoStar to sue, and the two went back and forth. And now they've settled, but we know why they settled. They're being very blunt about why they settled. And that is too expensive to fight.
It happens.
It does. And basically they have agreed to pay $1 million to CoStar for the copyright violation, saying, and from what we've seen previously, like with the Happy Birthday case, that's way cheaper than drawn out litigation.
Right. You know, I don't see how a real estate aggregator like these guys, if that's what they do, correct me if I'm wrong, how do they possibly avoid copyright issues? Because every single photograph is supplied to them by their realtors, and unless they have each of these realtors sign an indemnity clause, which I doubt they would, how are they supposed to ensure that they're receiving photographs in which these realtors have the rights to?
I mean, my first thought is you could, it would be a tough argument, but you could theoretically rely on safe harbor under the Digital Millennium Copyright Act.
Right. That's the other issue, is that I don't see why they wouldn't have a very robust DMCA system. Because that seems like exactly the type. This seems like exactly the type of company that would need to rely on it. It's hosting. It's hosting the content of third parties.
Mm-hmm.
You know, and it should offer these photographers or whoever owns these copyrights, whether they be real estate companies or real estate individuals or individuals who own the homes, the right to, hey, that's my photo. Let me take it down, and that way they cover themselves.
And I'll also say this, that the little bit of work Crystal did in real estate photography, those photos get passed around and shared so quickly, so breathtakingly quickly.
Of course, everybody wants their commission. Here's the house. Do you want to split the commission? Can you sell it now? I know you have a buyer, so.
Yeah, it's like instantaneous. You think stuff is shared fast on Facebook, you ain't been in the real estate market. You know what I mean? It's that crazy. But yeah, I don't understand how they could not have that type of system in place and hope to succeed unless they have an army of photographers they employ directly to take these photos. Now, one thing I did find that was interesting was, as part of this settlement, CoStar agreed to make some changes on their end to sort of help RealMassive out, and one of them included putting visual watermarks in all their photos.
Right, that seems like a very delayed, late thing to do if you're in the business of protecting your intellectual property. You know, if you want to protect your intellectual property, put watermarks on it. You know, if you're a photographer, could not endorse that concept more highly.
I agree, but you know, when a NASDAQ listed company is not doing something that the photographer that probably runs in the corner shop near you definitely does,
it's behind the eight ball.
Yeah, it's a bit behind the eight ball. So it's kind of bizarre, but yeah, in the end, I think it is a mutually beneficial settlement. RealMassive gets to move forward with some clarity and some certainty, and they do so for paying less than almost any amount of serious litigation would have cost. Yeah, it hurts to sign $1 million check, but at least this gives them a clear path forward.
Yep. Well, that clears our path forward to the next story.
Yeah, I really wanted to get your insight on this one a little bit, because I'm familiar with lots of areas of law, but trial stuff I'm less so. So this one I really want to turn to you. Jookin Media equals 3. Now, Jookin Media, I had to look these guys up. They are a company that basically gets the rights to viral videos or viral-ish videos and then licenses them to TV and elsewhere.
Right. They're an aggregator that, and this is very important, licenses and aggregates viral videos.
Right.
Right, and they basically have accused 3 studios, equals 3 studios.
Equals 3 studios. Yeah.
Right, have been accused of stealing their clips, and the Equal 3 Studios is trying to allege fair use. Now, I looked at what they were doing. I looked them up, and they basically are doing like a Tosh Bueno style commentary on these videos. So I wasn't convinced. I was surprised that the judge initially found most were transformative. And then it made a lot more sense to me when it went to trial and no fair use was found at all.
Yeah, and that was the first element about this case that confused me a little bit. The judge ruled that the vast majority were fair use, but didn't enter the ruling for some reason. And then the case went to trial, and the jury, it seems, completely reversed what the judge said.
Right. Well, I'm really not sure here, John. I would probably it would take I'd have to go look through the judge's orders. You know, it would surprise me to hear him with spouting an advisory opinion. That's not what courts do. But unfortunately, I don't really have an answer for your question as to why. I think this could be a reporting issue, where they say that the judge found most were transformative use. What that could be, and what it likely is looking at a judge's refusal to grant summary judgment and saying that while I'm inclined to believe that most of these are transformative, I am not
for the jury.
It is not up to the standard of summary judgment where there's no material fact or genuine issue of material fact, or to where a jury or no reasonable jury could find that it is transformative use. So I'm going to decline to rule that this is as a matter of law, this is transformative use, which is really the right thing to do. And so he ordered that it went to trial where no fair use was found. So that's probably what happened.
Yeah,
because
that makes a lot of sense.
If a judge, like I read the same as you did, that they reported that the judge found that a majority of videos, other than 3 of them, out of something like 48, that the judge found were fair use. But if they proceeded to trial, then he obviously did not grant summary judgment on those.
Yeah,
so that's probably what happened. It's probably a non-legal mind interpreting a refusal to grant a summary judgment, but I have not read the whole case, so I wouldn't take that all the way to the bank. But that's my instinct.
Well, and then comes the other question, which is the whole jury verdict we're talking about is moot, basically, in this case, because whilst the jury was off deliberating, the two sides reached a settlement.
I think that the jury was deliberating damages in this case, right? Because from what was reported is that no fair use was found. Now, if the jury has found no fair use, that's the affirmative defense that would be deliberated after our finding of infringement, which is clear in this case, right? Because we had a reproduction of the exact clips that Jookin Media licenses. And so finding no fair use, obviously they ruled in their favor, and they may have been deliberating damages. And while that was happening, the company settled, which happens quite often.
Okay. So that makes a lot of sense. See, this is why I like talking to you. You make sense of the confusing stuff for me.
You know what? That's my pleasure, John.
You really come through very consistently on this. So, yeah, that sounds perfectly reasonable. And long and short of it is, and this is what I find to be the most important thing, is that the jury did not find fair use. And we've been seeing a lot of debates on YouTube about exactly these kinds of videos. And now that we have, an actual jury ruling on pretty much, this type of like reaction channel type stuff, it should give some pause for some YouTubers, I think, who might be playing a little fast and loose with copyright law and the content they're reusing. Well, MP3 Skull, this is kind of interesting and bizarre. MP3 Skull is a site where you can predictably download MP3s and skulls. Maybe not skulls. Maybe mostly just MP3s, though. Mostly just MP3s. But the long and short of it is the RAAA, or the record labels, I should more accurately say, have been involved in litigation with them since April 2015. They've called it a very popular rogue website, once again playing Scrabble here, devoted to, quote-unquote, the massive, brazen, and egregious theft of millions of copyrighted sound recordings and worshiping Satan himself. But yes. But the problem is, as often is the case with these piracy sites, no one has showed up to represent MP3 Skull, and now the RAAA has gotten a default judgment against MP3 Skull a $22 million default judgment, which they're unlikely to ever see a penny of, if we're going to be honest.
Right, a default judgment occurs when the person you're suing just doesn't show up to court at all.
Yeah, and long and short of it is but it also got them an injunction that they are now going to apparently take to various providers at MP3 Skull to try and get the site shut down or at least hampered.
Right, we've heard this story before. I think every few weeks we get one of these.
Yeah.
Which is that somebody asserting the rights of musicians or labels or, fill in the blank, has found another one of these file sharing companies that has popped up and has sued them, and they've received the default judgment. And then, in a few weeks we'll read that either they're going to try to find the person who was behind it, and there'll be an issue of whether they can use IP addresses to find who this person was, whether they can sue somebody in like a John Doe capacity, or this kind of just falls on the wayside and we never hear about it again.
Yeah, that's pretty much it. And MP3 Skull right now, by the way, is still online, but that's kind of expected. I mean, this has been going on, like I said, for almost a straight year now. It started in April 2015. It's taken this long with no one showing up or doing anything to get to the default judgment, which is actually pretty common.
Right.
Every time I've only been involved in litigation, my own litigation, I should say, a couple of once actually, actual litigation. And the first thing the lawyer warned me is, be warned, nothing happens quickly.
No.
You will go weeks, months, possibly even longer without hearing a damn thing, and it will make you pull your hair out if you're not expecting it.
Yep. Lawyers are usually overwhelmed with work. Otherwise, things are bad, as they say in the in the legal market. So between all the clients usually have to serve and how backed up most courts are, it takes a long time for anything to happen in litigation.
Absolutely. All right. Next up, the U.S. Copyright Office on the making available right.
So in Europe and in other parts of the world, even making something available for download is an exclusive right. So to illustrate this, in the old days, we all had, yes, of course, I'm ashamed to admit it, Napster, etc. And you made a song that you owned on Napster available by agreeing to be one of the seeders. Now, if nobody downloaded it off you, did you violate somebody's copyright? So, according to the plain letter of the statute, no, because you have to actually reproduce it or perform it publicly. So there's this other right called making available, which is that you are the only one who can actually offer it for other people to enjoy in any capacity or reproduce, etc. And because that right does exist in other parts of the world, and because we have various international treaties, including the WIPO, World Intellectual Property Organization Copyright Treaty, and the WIPO Performance and Phonograms Treaty, there was a question of whether the United States is compelled to add this right into the Copyright Act, to legislate this making available right as plain language. Now, this was looked at by the Copyright Office, and they've come out and said that while not explicitly enumerated by the Copyright Act, the way it's been practically interpreted and governed, the right does exist, and it's kind of siphoned through other rights. The quote,
the publicly display and perform right, and I guess the distribution right too.
Exactly. So the quote was, although the United States approach to the making available right differs from that of its treaty partners, the majority of which have implemented the right through a broadly worded right to communicate copyrighted works to the public, both approaches are reasonable and effective, and indeed both are sanctioned by the treaty language. It's their fancy way of saying, it sort of exists already, so we don't want to bother.
Yeah, and they also said that adding the right in could do more harm than good. Going back and performing surgery on copyright law to add this right could, be a bad thing in many respects. And one of the things I found interesting was the press release bombardment that happened after this was pretty interesting, because a lot of organizations, especially I think it was the RAAA or the MPAA, one of the others, were sending out press releases saying, we welcome this, this rule, this report from the U.S. Copyright Office. and we fully expect and encourage courts to accept it. You know, this wink, wink, nudge, nudge, you better listen to it, because that's one of the problems is the U.S. Copyright Office, you know, stating its position, but it's not binding in any...
No, it can't exactly come out and say, hey, this right does not currently exist because so many of its private industry partners does not want them to say that, because then anyone who does make it available can then quote this as a persuasive, not a persuasive authority, as a non-binding authority, which I'm sorry, is the term of art of persuasive as opposed to binding. It is merely persuasive. They don't want an official record of that. So if you combine that with the fact that the likelihood of getting any sort of copyright, or by that matter, any legislation passed in Congress, then it's really self-serving to find a way to say that, oh, it exists already. Because
I hope the courts play along, I guess.
Exactly. So even though neither one of us could really confirm that that's why they came to this ruling, it kind of makes sense, doesn't it?
Yeah, and the reason this is so important is not actually because of but it is because of situations like you described, where you put a song out there on a file sharing network, and someone may or may not have downloaded it from you. The issue is what's easier to prove.
Exactly. Think about how much easier it is for any intellectual property owner to find their work online and that be enough, right?
Right.
You know, of course, there's still the DMCA and all that other stuff, but behind the scenes to have actually, you know, you got to do the discovery to figure out if it's been downloaded. Maybe you have to eventually call and get the person who downloaded it to testify for you, or at least take a deposition, or there's so much more to do.
Yes. Than just saying, hey, look, there it is, there it was.
Exactly.
Bang, bang, boom, we're done, we're out of here, wrap up shop early.
Making available is, in every sense, a stronger copyright regime than only having the right to public performance, public display, reproduction, etc. Making available is really the next step in intellectual property rights. And so...
And the Copyright Office on record saying it already exists, and we can all go home.
We can. All right, let's move on.
Yeah, 100% licensing. This is a pretty interesting concept. This is another one that involves the U.S. Copyright Office. I had not actually heard the Department of Justice was making this move until this story. I was completely unaware this was going on. But basically, the Department of Justice, as we've discussed before, has a consent decree on Ascap and BMI, the two largest performing rights organizations. Basically, those two organizations got so large that they were able to bully people trying to license music, and the DOJ stepped in and put consent decrees on them. Now, one of the areas at issue here is this idea of partial licensing.
So, okay, John, maybe help me and the listeners understand this. By 100% licensing, are they saying that in order for any performance rights organization to be able to shop and any piece of work, they have to have the consent of all co-authors, which means that they need to basically...
No.
Okay.
That's not what they're saying. What they're saying is, under U.S. law, a work of co-authorship, like this podcast here, we're co-authoring it. You and I both have the rights to enter non-exclusive agreements.
Right. Co-authors both have the rights to shop their work,
yes,
as long as the agreement that they make is non-exclusive.
So, as long as the revenues are divided amongst the rights holders.
Correct. So if I can go to Fox and be like, hey, you know what, the biggest thing is going to be on your Friday night programming? Televised copyright podcast.
Yeah.
And I go and I sign something with them. As long as I do not say, hey, you have the exclusive right to this, which of course would be invalid because I don't have that right without your consent also, John.
Yes.
I can make whatever deal I want with them, and then you could go to NBC and be like, hey, you know that new show on Fox? I've got the perfect thing for you.
The same thing.
Yeah. All right, so go on.
And basically what the DOJ is saying is that if one of the PROs has 5% or more of the work, that they should be able to do 100% licensing. Because previously, what would happen is a song might be broken up among 2 or 3 or even now 4 PROs because we're losing record labels and gaining PROs. It's one of those weird things. But so you might have to, just to get one song, obtain licenses from 2 or 3 groups. And what they're hoping is that, what the DOJ is hoping to do is say, okay, look, if one PRO has 5% licensing, then you have got 100% permission to play and use that song, and the PRO has to deal with doling out the rest of that money.
So isn't that essentially the same thing that I was saying, though? Does that mean only one PRO can have the rights to any piece? It has to have 100% of it?
No, basically, if like a song, my understanding is if a song is broken up 50-50 between Ascap and BMI, if I just have an Ascap license, then I pay all the royalties to Ascap, and then they will give that other 50 to BMI. But I can do the same. I can license it from BMI, and in turn, they'll have to settle up with Ascap. And
they want to change that?
No, that's the way.
Oh, that's the way they want to do it. Okay, gotcha.
That's the way they want it to be. The way it is now is you need both licenses.
Yeah, this part of copyright law is not my forte, so I'm glad
it took me I have gotten more aneurysms from music licensing than pretty much all other areas of copyright law combined. I'm pretty sure I have permanent brain damage from actually trying to learn this. I'm probably like an NFL player. I'm going to have a shortened lifespan because of this. But the point is, though, yeah, right now the way it is you have to get a license from all the PROs that have any piece of that license. They're trying to make it so that you can get 100% of the license from one PRO, and that PRO has to settle with the others who hold pieces of that license.
I got you.
And that's the way they're trying to make it. However, the Copyright Office has stepped in and saying, not every country works the way we do with co-authors, and this could be illegal with foreign authors. Basically,
seems like it could be a problem.
Yeah, it seems like it's a pretty big problem. It could be easy to overlook. And the U.S. Copyright Office also says that it would really hamper a lot of these new PROs that are coming up, like CSAC and Global Music Rights, which are a lot of their business right now is these partial, licenses that they're able to scoop up. And without those partial licenses, why would you, ever work with them directly? So this is a really interesting battle, because the argument is obviously everyone wants better, more streamlined, more effective music licensing. But here you have an anti-competitive issue and also a legality issue when looking at foreign copyright holders.
See, I'm reading the story now, and I think from what I'm reading here, it seems that from what I was saying might be correct in the end, because it says that the change will require performance rights organizations, namely Ascap, to allow 100% licensing, which would give the partial owner of a song, regardless of whether their share of the work is 5%, the ability to license the entire work. So,
yes.
Okay, so
just like co-authors can do.
Oh, no, but they can't. Co-authors cannot do that now. They cannot get a total exclusive license from a...
But does it say exclusive license?
That's what it's saying here, is that they right, regardless of whether the share of the work is 5% or 50%, this new consent decree would require them to receive a 100% license from that person, which is just impossible.
Maybe I misunderstood it then.
Anyways, let's move on here, because
if I misunderstood it, I apologize. I am an idiot sometimes, and like I said, I've gotten more aneurysms from this than anything else.
So I thought that requirement, and it's certain that requirement, is in contrary to U.S. copyright law.
That would definitely be, yes.
As we discussed, a co-author cannot grant an exclusive license, and the DOJ requiring them to receive a exclusive license from a co-author it's just not workable.
I agree. That would be insane, and that would actually add a lot of complexity to music licensing, not take it away.
Agreed.
Because now you've got all these PROs scrambling to get 100% rights to various songs, and it's going to be one of the most interesting games of Go Fish you've ever played in your life.
Hi, John. You licensed this to us 16 years ago. Do you remember who you wrote it with? Because we need to talk to them.
Yeah, we need to talk. And
it seems untenable to me, but let's move on. I'm gonna let you pick the next one because we're all over the place here. Okay, the Batmobile.
Batmobile, yeah. This That story didn't go so good.
So we talked about the Batmobile case last episode or 2 episodes ago. I encourage listeners to go and listen to that, because we talked about this issue in depth, and I don't think we have the time or the patience to do that again right now. But the gist of it is that the Ninth Circuit of Appeals decided that the Batmobile deserved copyright protection as a character, that it was sufficiently delineated, which is the term of art in character copyright, to deserve copyright protection. John and I believe, both had a bit of an issue with that. We thought that really there should at least be some sort of personification of an inanimate object in order for it to qualify for character protection, because then really, what is a character? It become, is a mansion a character now? Is the is Bruce Wayne's manor now a character? We thought that there was legitimate arguments for the copyrightability of the Batmobile.
Yeah, and I think that one of the things we discussed was that the Batmobile, at least the two that were involved in the 1989 Tim Burton film one and 1960s TV one, they both had sculptural elements which are separate from the useful article elements.
Exactly, and
which might be a workaround of this to still give copyrightability to the Batmobile, but not raise this character issue.
Exactly, I think we came to that conclusion together, that would have been the way to go, but that's not what happened.
No. So a car is a character, and
right. It's now so weird. I like the sufficiently delineated test. I do, but maybe it was just misapplied here.
Yeah. Well, we're not going to get hear any more about it. It appears, because the defendant in this case, Mike Tolley, a California mechanic who made 2 Batmobiles, one in the 1960s and one in the 1989 one. He lost both in the District Court and the Ninth Circuit Court of Appeals. He appealed to the Supreme Court, and that's the reason we're talking about it. The Supreme Court said, nah, basically, we're not taking it.
Just quickly here, in case our listeners don't know, there's something called the especially distinctive test, in which characters, which are, quote, sufficiently delineated, and that display, quote, consistent and widely identifiable traits merit copyright protection. Now, this comes from a case called Nichols versus Universal Pictures. It comes from 1930, so it's an old test. And it's a great concept of trying to figure out what's the difference between a stock character, witch with pointy hat, or, spy with gun. There's a difference between that and James Bond, who has, consistent, widely identifiable traits that makes James Bond a protectable character, as opposed to merely a stock character, which, can be used. You can have a British spy in your movie. It just can't have everything that James Bond has. So it's a great test, but it should be restricted to characters. The Batmobile has never been a character. It has never been alive. It is not... help me out here. Right? It's not Knight Rider.
It's not Kit from Knight Rider.
It is not Kit from Knight Rider, which is a character who you identify with, who has lines, who plays some sort of role other than an inanimate object. So I really could not disagree with this more strongly on that basis.
Yeah, and it's really interesting.
You know what? I think I might write an article about this, because...
Yeah, you should.
Because I feel like if you go through the history of the test, and this is really spitballing here, and I can let you know once I get more deeply into it, how many things or items or I think things is the only word I could really use in the history of the test have found to be characters that have never had a spoken line before.
Yeah, that'd be interesting. And I guess you would have to go back to maybe some silent film characters and so forth. You might be able to find something.
Right. Well, I don't think the fact that they don't say anything in sound is really the dispositive issue, right? Because if they have lines that are coming up in text, that makes them a character in some capacity, right? I think that if you delved into the science of theater, in that what makes a character, I think that dialogue is obviously a huge part of it. Is there more though? Can you think of?
I think dialogue is less important than behavior.
Yeah, you're right.
Behavior. It doesn't have autonomy to have behavior.
Some sort of personification. It's not necessarily dialogue, but behavior that animates it. Some sort of animation. And the word you used was really right. Some sort of,
Yeah. It's gotta be anthropomorphic.
Dialogue, exactly.
Now, okay, interesting bit of trivia. I looked this up to make sure I wasn't wrong, and I actually kind of was. What does KIT stand for?
I have no idea, but I'm going to take a guess.
Okay.
Wow, I don't even know. What could K possibly stand for? Give me a hint.
Okay, I'll give you the first one. I'll even help you out a lot here. Remember, KIT was developed by Knight Industries.
Okay, so you must be Knight.
Mm-hmm.
Knight Information Technology?
It actually stands for Knight Industries 2000. And that was the part I remembered. The part I was wrong about was that when they did the reboot of it, the other version of KIT was Knight Industries 3000. Lucky dog, those two numbers had the same letter.
So that's kind of funny.
Let's hope they never do a fourth, because then it'll be like Donald Duck just trying to say it. But yeah, so it'll be interesting. But yeah, KIT is definitely a character, and KIT in my book is the only car that will be a character.
You know, John, why don't we co-write something here? We could do some work together.
We definitely should. That'd be a great idea.
And we could release it, and because I think we're both of the same mind on this one.
Yeah, I think that'd be a great idea. I'll touch base with you after the podcast about getting that done. I'm going, like I said, I'll be at South by for a few days, but after I get back, I'd love to do that.
All right, perfect. Well, I think that brings us to the end of our podcast. It was great to do this again.
It was great. I love talking to you, and it's been a fun show. Very informative, and only one absolute train wreck this episode. So we're doing good. We're improving.
That's usually an improvement.
That's an improvement, actually. It's a pretty big one.
Right, and in our defense, the train wreck was on performance rights.
Probably the worst area of
copyright law. I agreed.
All right. Well, on that note, everyone, my name is Jonathan Bailey. I am from the website Plagiarism Today, which can be found at plagiarismtoday.com. And I am at Plagiarism Today on Facebook, Twitter, YouTube, all the interesting sites you might happen to be on.
And you could find me, eshares@gmail.com, or if you want, evan@amalfihome.net if you happen to have any business with my company. John, have a safe flight.
Actually, I'm driving. So
have a safe drive, which is much more dangerous. So
yes, it is.
Well wishes are that much more poignant.
Yes, it is. I appreciate it, and we will see you guys next time.